Slightly hard. Good afternoon, ladies and gentlemen. Allow me to welcome you to the opening of the 25th anniversary celebrations of the European Centre for Minority Issues. My name is Velo Katai, and I'm the director of the ECMI. And it's a great pleasure to see so many of you here, notwithstanding the pandemic challenges that we have, of course, at the moment. And we certainly have to not take lightheartedly the need for safety and for care and vigilance during these difficult times. And yet at the same time, it is equally heartwarming to know that by you being here in so great numbers, that you share a continuing commitment to European minority issues and also to the ECMI by extension. Now, European minority issues, of course, have a very long history. They go back way beyond the creation of the ECMI in 1996. And some of this history has certainly not been very pretty. During both the interwar period and later during World War II, in the post-war period, and even after the end of the Cold War, there have been challenging times in this realm of minority issues. At the same time, a lot of major improvements have been achieved and have occurred, such as the creation of a European legal framework for monitoring and sometimes even enforcing national minority rights and standards. So it is important to note that within that process, there actually has been also a kind of quasi-mainstreaming of minority issues, also among the relevant governments, the relevant member states in these different institutions, as well as the deepening of minority community awareness and mobilization about their rights. And lastly, of course, we have added perspectives from scholars and academics who have gained and offered a lot of comparison and theorization about these developments. So these are the issues that we want to bring out today as part of this opening anniversary panel on the European minority issues from 25 years ago and today. And we aim thereby not only to reflect on the last quarter century, but also to give it meaning by conceptualizing four important interacting realms of this broader phenomenon. And I've already alluded to some of them or to them, but let me briefly elaborate before we begin. So the horrors of the Second World War, of course, demonstrated that the protection and furtherance of national minority issues in Europe needs really multilateral, intergovernmental exchange and systems that would generate soft, if not actually hard law. And this has come to fruition through, of course, three main pillars that we all know about, via the Council of Europe, via the OSCE, and via the European Union. And it's assorted offices and treaties and programs and policies. And so all of these institutions, all of these offices have become systems in and of themselves. Of course, if we think of how far the Framework Convention has evolved, in over 20 years. And to sort of pack them under one roof and say one, European system is fraught with oversimplification, but at the same time, they also work together, right? So they're not standalone institutions in this landscape. And to such an extent these days that we call it the European minority rights regime, even. And so for political scientists, regime already means something for me. So I take quite a lot of awe in that phrase. But still, we need to ask, what is the degree of palpability or tangibility of this minority rights regime? Do we really feel it as an interlocking system of multilateralism that is in place, or is there still more work to be done? Secondly, even if the countries of Europe have developed this set of interlocking and intergovernmental institutions, what benefit has any of this brought to the minority communities themselves? Have minority groups found tangible and effective protection within these systems? Or has the progress that minorities have achieved over the last 25 years really been via their own bootstraps, as it were? Right? And that they've all achieved what they have through their own efforts, and perhaps despite or notwithstanding the existence of a minority rights regime. Because we know that we can have any number of legal frameworks, but a lot of other core issues, such as socioeconomic disadvantage or discrimination, or more modern phenomena like cyber hate speech, are things that cannot be immediately solved with the signature of a treaty or the establishment of some office. Thirdly, a lot of or few solutions in this realm can be achieved without the work of actual policymakers and officials. And yet the responsibility of those people is also very manifold. On the one hand, of course, we could say that these are the same people who design the treaties. And they're the politicians who first go to Strasbourg and set the system up the way it suits them. But over time, of course, the system is supposed to grow on top of them. It's supposed to become overarching above them. And therefore, they actually have their own role to play in fulfilling these and navigating these systems, whilst also remaining responsive to minority communities as policymakers, to their own citizens. And lastly, of course, there's the element of addressing some of these political issues when they are in a political minefield. As politicians, or even as policymakers and civil servants, they have to be cognizant of those challenges. So that role that is played indeed by government representatives and civil servants is equally very important. And lastly, of course, the realm of minority issues has an analytical dimension to it that academics play first and foremost in devising legal frameworks, giving ideas for procedures, modeling different accountability systems so that things work out logically and effectively, sometimes also monitoring interactions, socio-political interactions, or even doing work on the ground, so in a sociological manner with minority communities. So they can serve also a comparative function. Right? They're the ones who can see beyond their own plate, as it were, and bring together not only regions and countries, but around the world. And that's something that I think is very linked to the academic function. And yet we can still ask whether scholars have been been playing some kind of avant-garde role in offering ideas, or just simply working as watchdogs and critiquing along the way in their ivory tower, and not necessarily helping the day-to-day work. So those four areas, the institutions, minorities, government representatives, and then academics, are those that we hope to cover in today's panel. And surprise, surprise, we have four speakers here to my left and to my right who will be addressing these. And allow me then to introduce each of them, and then we'll immediately get into discussion. And I will begin here to my left with Professor Dr. Rainer Hoffmann, who holds the chair for Public Law and International Law at the Goethe-Universität in Frankfurt am Main. And he is also the co-director of the Wilhelm Merton Center for European Integration and International Economic Order. And in addition, of course, many of you know, and I think all of us in this room know him as the former president of the advisory committee for the Framework Convention on the Protection of National Minorities, and he served on the committee for 8 years. So he has been given perhaps also the thankless task of commenting on the European institutions, but that is going to be, as I said, one of our 4 pillars. Next, we have Laura Vinchak, who is then the president of the Federal Union of European Nationalities, and also a well-known face in this crowd and in Flensburg and beyond. He is from the Hungarian minority in Romania, as many of you know, and originally worked as a journalist and publisher, and then entered politics, and now, as of 2019, is a member of the European Parliament. So he is well placed, of course, to comment on the impact of the last quarter century on minority communities. Thirdly, I'm pleased to welcome Linda Pieper from the Staatskanzlei in Schleswig-Holstein, where she is advisor on minority issues. And so she liaises very directly with minority communities, as I said, and aims to be responsive to the needs of the minority communities in this area, but also works and liaises internationally because, of course, Germany is also responsible for its obligations internationally, and she sits a little bit in that hot seat with these different realms around her. And last but not least, I'm pleased to welcome Jennifer Jackson-Priest from the London School of Economics and Political Science, where she is associate professor of nationalism. I guess that's what she preaches and teaches. But she's, needless to say, also has a distinguished scholarly career studying these issues, minority rights, minority issues, and even with a perch as beautiful as London, we can still ask, how can academics have an effect on minority issues? So I will conclude and just say that each of the panelists has been asked to speak for 10, 12 minutes, 15 minutes as an introductory statement, and then we will try to have a discussion, also with questions from the audience. I'm afraid we're not able to entertain any questions from those people watching online, but you are free to write to us via Facebook or Twitter or any other modern communication medium. So, but without further ado, Professor Hoffmann, what would you like to invite us?
Thank you very much indeed also for the invitation to come to Flensburg again and for start speaking on institutions. I just wanted to share some impressions with you, which I got being on the Regionalzug from Hamburg today, that brought back memories from, I think it must have been spring '95, and I traveled for the first time to Flensburg as a member of the founding board at that time of the ECMI. And that was quite an interesting period, and it was not yet quite clear which direction ECMI would go to. And we were the members of that board, in particular, a Danish colleague, Henrik Christensen, who was quite influential at that time in pushing or moving ECMI in the direction it actually worked later on, and not becoming an additional border region research center, but a really pan-European institution research on minority issues. Obviously, 25 years ago, with the Prince and Heidi Simonis here for the inauguration, what many people probably have forgotten was that there was a lot of criticism about ECMI at that time. If you feel you want to go about it, have a look at the parliamentary paper. The Bundestag will find a kleine Anfrage of the Green Party, whether the government really is that happy about that ECMI seems to be cooperating with an institution called FUE. Amazingly enough, was supposed to be, in the view of those people at that time, to be considered, I don't know, rather völkisch was the term used. That's eine Anfrage. So things do have changed over the time, of course, and thanks to a number of persons who you all know. I mean, you had those directors of the board, the Jürgen Laden, and of course, Jürgen Kühn here, and directors Mark Weller, Tore Malloy, and Stefan Tröbs. That was one of the first decisions we had to take at that board, who was going to be the founding director at that time. Unfortunately, he left after only 2 or 3 years for Leipzig, but then there was like some kind of interregnum before things got working again. Institutions. We all know that probably the starting point for the renaissance of minority protection in Europe was the Copenhagen document in summer 1990, the OSCE, or then still the CSTE, which took the lead. And the major event in that context, obviously, was the creation of the Office of the High Commissioner for National Minorities, institution for silent diplomacy, preventive diplomacy. I think very much depending on the personalities who held that position. I mean, it was obviously very fortunate that the first High Commissioner on National Minorities, Max van der Stoel, was a very important and well-connected Dutch diplomat. And I think it was also due to him that the relationship between ECMI and the OSCE High Commissioner started very well. I think he gave the first speech here in Flensburg in autumn '97, when he traveled from The Hague to give the speech on the what could be expected in Europe, meaning that was still a year before the Istanbul Convention entered into force. The office has produced, in particular in the 1990s, I think quite a number of very valuable soft law documents, guidelines, in particular on various aspects of minority relations. I think it is justified to state that for the time being, the office is not as not as vivid, not as lively as it used to be. That is not the fault of the people working there, but it's the fault of the consequence of the situation with the OSCE in general, as we all know. And I think the office has never really recovered from the blow it received as other institutions from the annexation of Crimea in 2014 and the ongoing rest of Eastern Ukraine. And I mean, I think if you get that old as I am now, I mean, you know, of course, the persons matter. And I think High Commissioners like Max van der Stoel and Knut Vollebeck can't be that easily replaced. And we will see what happens with the EU situation or what happens with the OSCE in general. The Council of Europe then started more or less soon afterwards in the early 90s. As you will recall, the first idea was to draft an additional protocol to the European Convention on Human Rights, which was very much propagated by the Parliamentary Assembly. In the Vienna summit of the Council of Europe in 1993, that plan was abandoned, and the decision was taken to draft a framework convention. What actually then happened, notwithstanding that there already existed since '92 the European Charter on Regional and Minority Languages, which was at that time more considered to be part of the activities of the Council of Europe in the fields of culture and in the fields of human rights. And it took only until a few years ago that the two bodies really got merged to some extent. As you all know, the Secretariat is now serving one Secretariat serving the two bodies. The Framework Convention actually entered into force then in '98. Some of you will know that the ECMI played an important role in getting the advisory committee started. There was just before we had our first meeting early July in Strasbourg. There was a large conference, and if you look at the members, other persons who participated in that conference, it really reads like a who's who of minority protection rights. At that time, among them was Ole Espersen, who gave a fantastic speech on the future of minority protection in Europe at that time. And it gave quite a number of members of the advisory committee possibility to meet with their future colleagues of the Secretariat and to discuss for the first time which way they wanted or we wanted to go. I think one of the major achievements of the Framework Convention was the unexpected quick ratification process. It just only took 3 or 4 years for that document to be ratified by 39 member states of the Council of Europe. That number has remained stable, if you want to call it like that, over the last 10 years. And I don't see any of the remaining countries which have not ratified it yet to do so in a somewhat near future. The relevance is also reflected, I think, by the fact that UNMIC concluded an agreement with the Council of Europe in 2004 that the monitoring apparatus of the Framework Convention was to be applied also for Kosovo, which was an important aspect, and that still goes on. I mean, as you know, Kosovo is, due to some political opposition, not yet a member of the Council of Europe, and will probably not become a member for some time to be. But like via this agreement, there is at least the applicability of that convention there. I think the other major achievement of the Framework Convention is that you have, Director just said, I mean, you have a monitoring mechanism in place, which is well working more or less 23 years now. Fifth cycle of monitoring. The system, I think, works relatively well. We have since 2019 a new development, which I personally always thought that was not a good development, that is a kind of what they call the confidential dialogue. So once the advisory committee has adopted its opinion, it will not become public yet, but there is some kind of confidential dialogue, as they call it, between the government in question and the advisory committee, to sort out factual mistakes, as the memo was. That procedure is borrowed from ECMI, and it has been also used by my colleagues in the charter. I always thought it risks the independence of the advisory committee, but so far, at least my impression is that it has not, that my year was not justified, and that the advisory committee is fully continues to be fully independent and formulates its opinions in their opinions as they wish to do. We have, I think it is fair to say that the advisory committee has become and that is probably a development which was by no means foreseen in '95, has become the major standard setting in minority issues in Europe. It is not the Council, it's not the Committee of Ministers. In the original structure was that it was an advisory committee which should advise the Committee of Ministers. Committee of Ministers, a political body, to draft the actual recommendations. I think the relevance has turned around to some extent, and I mean, if someone in Europe wants to know what are the standards of minority protection, you look into the opinions of the advisory committee. I'm of course biased in saying that I've been 10 years president of that committee, as I was saying, but still, I think it can. There are probably others who would join in that assessment. I think it was also important to try to establish something what we call the continuous dialogue, that you would have it's called follow-up seminars, so you would not have a report and an opinion and then 5 years of no connection. Whether that's really, well, that is one of the discouragements that this has not really been achieved. There are some countries who follow that idea of continuous dialogue. There are quite a number who do not follow that dialogue. When it comes to substance, I think it is clear that that it has been accepted that the Framework Convention, as any other human rights instrument, is a living instrument. So new challenges, some of which were just mentioned, have to be tackled by the advisory committee. IT issues, I mean, obviously, that those advantages, hate speech that is one risk, of course. On the other hand, we all know the chances one has with new media, with the internet, for language education and what have you for minorities. And that, I think, is something which has to be used and developed by the younger generation. And I attended a conference in Lison 4 weeks ago, and it was quite amazing, or quite impressive how, well, not amazing, impressive how people in the 20s were think about the internet, how they can use it and what they can do with it. So maybe our concern about print media is somewhat outdated. We might have to change our mind, might have to change our opinion on that. Still, there's one point I just wanted to raise or mention. The system is a system developed in the 1990s. It's a classical monitoring system. You have state reports, you have opinions, and you have reactions. That's it. And maybe we should try to find more dynamic solutions using digital platforms where NGOs can put their information, where state governments could put their information to get that idea, the whole idea of an old continuous dialogue working more properly. In general, I think the Advisory Committee on the Framework Convention is suffering from the same development as all other human rights bodies. States are getting less and less prepared to submit to international scrutiny. And if you just today, I mean, you heard that the Council of Europe is starting infringement procedure against Turkey. We see that was, I mean, the position that the Turkish government has via Mr. Kavala, I don't think that would have been possible 20 or 50 years ago. So, I mean, you all know that human rights are maybe under stress. Final word to the Council of Europe body, which has become more and more active in minority areas, the Venice Commission, in particular when it comes to Ukraine, Latvia, and other countries concerning legislation which strengthens state language in a way which some would consider as a risk for minority languages. We have the president of UN here, and there's one concern among the Hungarian minority in Ukraine, for example, that their 500 years old traditional gymnasiums will not survive that situation. The same goes for Polish and Romanian secondary school institutions. And I mean, to find a balance between this legitimate aim of strengthening the state language on the one hand, and at the same time preserving the equally legitimate demands and rights of national minorities is, of course, a very tricky issue. The last institution in that, and it is really the last one, also when it comes to its relevance, is the EU. I mean, I don't think I have to remind you of the widespread concern of minority safe back position. The Commission has been taken over and over again, and then I mean that we needed to lead the court to put things forward. That I think is a shame. And notwithstanding that Article 2 of the TEU has now the reference for more than 12 years now in the Lisbon Treaty to minorities, national minorities. We sometimes have the feeling that, for very obvious political reasons, of course, the Commission is doing everything they can do in blocking things, which, of course, is, I mean, that is a known issue. It's back to the 1990s, this discrepancy between the relevance of minority issues for the external politics of the EU for Copenhagen criteria. You have to fulfill IB, A, B, C, D, E in order to become a candidate country. But if you're in the club, I mean, nobody cares about you any longer. That's not true. If you have been a founding member of the club, then nobody cares about you. And that I could have told you 20 years ago. Nothing has changed since, and that is really, accepted or not. But that I think I'm afraid we cannot expect that much from the EU in the future. So it's probably the Council of Europe that as the international institution active in Europe, which will be the ally for minority issues. Thank you very much for giving me the floor, and looking forward to the ongoing state reviews later on. Thank you.
Thank you, Mr. Hoffman. Covered all the bases. Optimistic, pessimistic, both. But let's hear from the minority communities without necessarily just putting you in the single box, Mr. Bincher. But nevertheless, the floor is yours to hear from your members, your own community, and the minorities.
Thank you very much, and good afternoon to all of you. Thanks a lot for having me at this distinguished panel discussion and the anniversary of the ECMI. I would like to congratulate you for this for this milestone in your existence, and we as the FUN, quite neighbors actually on the street, we see you as a partner institution, and Professor Hoffman was right. That was not obvious at the beginning, but I think more and more it is today by practice, and I hope that we can count on each other with your expertise and knowledge that you brought up in the past decades, and the FUN with its network and lobby capacities, that together we are really able to deliver a lot on the front of minority protection. And I would like to praise also the region. So Denmark and Germany, the Land Schleswig-Holstein, the border region, for having these two important institutions here, and with the ECMI to have really this knowledge center in this region. Now, Professor Hoffman opened a lot of chapters. Basically, he enumerated indeed the main institutions, and from a minority community point of view, the main battlefields on minority protection. Maybe it is good if we go back a bit to the aims of minority protection, why we are here, why we speak about this topic in the first place. And this goes back to the identity question or identity approach that Europe is a diverse continent in which, if we look from a state perspective, there are majority communities, majority languages, majority population in a state, but there are also other communities that linguistically, culturally, are in smaller number than the majority, and we call them minority. Minority, from my perspective, is not a quality, and definitely not in a diminishing concept, but it's a quantitative appreciation of the size of the population. We often try to refer more to us as communities. And then, of course, there is a huge debate, still ongoing debate, on the definition of minorities. And I refuse to enter into this debate because I believe in the self-identification of the person and of the group, whether they consider themselves a national community or a language group or a regional minority or whatsoever. Definitely, we are speaking about communities that have been living on a territory for several generations, and they are part of the society. Now, because these communities are smaller than the majority, of course, they are more vulnerable to changes and vulnerable of losing the language, of losing the cultural heritage. And I think there is a moral obligation and a need of care from the general society perspective to support to make these communities live and to preserve the language communities and national communities. So, having this as a starting point, how can you ensure that languages, cultures are protected? It comes with legal provisions. This is obvious. Even having legal provisions, sometimes it is very difficult to implement the legal provisions. And I'm coming from Central Eastern Europe. I must tell you, in Romania, we have in place quite a good system of individual rights for the minority, but this legislation is not always implemented into practice. It's a fight, an everyday fight, how you manage to make the authorities, be them national or local authorities, to implement this legislation. But nevertheless, indeed, it's the legal provisions are essential. And yeah, I fully agree, even with the even with the European Commission, when it says that it's primarily the competence of the states to ensure the necessary legal conditions, the legal framework for minority rights, just that it does not happen. So when it does not happen, what to do? And then it comes this multinational layer, the international organizations that can have the role to somehow coordinate or to try to show what should be done at national level as well. And of course, you have the very natural answer of the states that reject this kind of intervention in their internal affairs. And that is the main debate that is going on in Europe for decades. So when I'm thinking about the main question that you put me in your letter, that what have European minority communities gained in terms of recognition, protection, and advancement over the last 25 years, it can be a very short answer to say zero, nothing. Of course, the picture is much larger. But when I'm looking to legal provisions, basically, we are bounded only by two legal instruments, the Framework Convention and the Language Charter. There's nothing else. In some states, they have been improved, and there's new legislation in place. But overall, looking from a European perspective, nothing happened. Now you would find another understanding of this phenomenon when they say that there is a fatigue in minority rights, this language that shows that there is a tiredness. So, but this would be true if everything is perfect, and okay, now really we cannot do anything more for the minorities, but we are not at that level. So unfortunately, I see also the two legal instruments from the Council of Europe that they should be modernized, and the new challenges of the society should be included, and it was evaluating this monitoring system. Indeed, the relationship between the advisory committee opinion and then the political level, the committee of ministers final act, how these two correlate with each other. And whenever there is a committee of ministers decision, what is then implemented in the member states, usually the last period, some states just say, okay, that's only another statement of the committee of ministers, we don't want to do anything. While you have also honest partners, and I always seen, but you can enter into a debate with me on that, but I saw Germany, Denmark as states that accept this criticism, and they try to, for the next round of monitoring, to implement and to change things. So since in the Council of Europe, we really see that the institution itself is not willing to make new steps, it is also linked to what happened in Ukraine with the role of the Russian delegation, of the Turkish delegation, the financial problems that the institution is facing. The other ground, the other battleground is indeed the European Union. Also because not all the EU member states ratified and signed and ratified the two legal instruments. Yet in the European Union, we say that we share common values, European values, that we want to hold to them, and we want that it is somehow a basket of values that everybody considers his, and to do everything to hold to that. But it's not as obvious as one might think, because the European Union is also driven by the national interest. And when I am looking to the European Commission's answer on the Minority SafePack initiative, it is a nation-state reflex that I saw in this rejection, and of course in the discussions on the corridor, it was clear that the national sensitivities that were raised by several member states led the Commission to the rejection of the proposals from the Minority Safe Pack initiative. Now, this is a 19th century concept that the member states have to do everything to protect themselves, not to let the small groups in the society to grow bigger, and they many times just forget about the added value of the minority, of the multilingualism in the regions, and so on. And the European Commission accepted this reasoning, which is quite stupid, I think, from their side, because there is only a small number of member states who really are against any intervention on European level on minority protection. But those who are against are quite strong. They are quite voicey. Baltic states is one that also Professor Hoffman mentioned, because of the Russian community living there, that they don't have yet citizenship, many of them, and so on. And it's they are a subject of a geopolitical fight. Then you have France with its concept of French citizen who can only speak the French language, so the regional languages don't matter, don't exist. You have Greece that does not recognize the Turkish minority living on its territory, and so on, including my country, Romania, that, as I said, offers individual rights to the minorities, and the Hungarian is the biggest minority in Romania, with 6.5% of the population. The other minorities are below 10,000 people. But Romania refuses to enter in this European level debate because they refuse community rights, and they don't want to hear any intervention from the outside, which would say that, okay, you have this large Hungarian community, please let them to handle their own education system, let them administer their cultural institutions, and so on. We are just treated as individuals by the Romanian constitution and the law. So we have these states that practically oppose any attempt to speak about legal provisions, though the Minority Safe Pack initiative was not a revolution in itself, because it made requests based on the existing European policies, European programs in various fields like audiovisual media, geo-blocking, or structural funds. So we could not ask for an implicit minority rights system that would be beneficial, but would go against the existing treaties of the European Union. And yet the Commission said, yes, we could adopt some actions in supporting the national minorities, but we already did a lot in the last decade. And this is also one of the reasons we don't want to adopt legal acts, which is, again, I repeat the word, it is stupid, because us as members of the minority communities, we know very well that from the EU level, there was no support at all for the minority community. So it is true that we have a legal action against the European Commission. It's an normal procedure, and we hope that we will gain again right in the Court of Justice of the EU, as we had several years back when the Commission, when the Court said that it is possible to adopt legal acts that would enable linguistic diversity and cultural diversity within the EU. It is also true that the European Commission is today fighting for the European values. It speaks about the rule of law, but it is also cherry picking in that field. So when we see that the European Commission is open to some minority groups or some concerns, while they are strictly rejecting any positive measure towards the national minorities. So it's not European, and it's not according to what they aim to do with our adherence to European values. It is also true, and I will finish with that from a historical perspective, the accession to the EU of the member states from Central and Eastern Europe was the last moment when new minority rights provisions were enabled in the states because of the Copenhagen criteria. The member states under pressure had to give minority rights, to give legislation, but once they became members of the club, they did not have to respect even those laws anymore, not to mention that it was really the last minute when the member states, at least from the eastern side of the continent, had positive measures towards the minorities. So that means that in the past 15 years, really nothing happened. What we achieved probably with the Minority Safepack initiative, and probably that's not little, to put on the agenda of the EU the minority rights issue. We forced, together with this large gathering, the big support of the minority communities, including those from the border region. We put the Commission, we confronted the Commission with our requests, and even if their answer was the refusal, there was one college meeting of the Commissioners of the EU that had to debate this matter. And I only hope that we will be able to continue the fight and not to give up, and try with all other means as well, including this conference on the future of Europe, to bring back the topic and confront the European Union and the Council of Europe with a double standard that they are practicing against minorities. Thank you very much.
Another resounding vote for bringing minorities back. And let's see, do European governments and government officials want minorities back, or how do they feel about their work and what has happened? Please, Linda Pieper.
Thank you. Thank you for inviting me here. Well, you asked me to reflect on the question, what has the European minority regime brought for European governments? And I want to start this reflection with an example from my professional experience, and it's about 10 years ago. Many of you will know what I will talk about, and it starts like that, a part of efforts to consolidate the budget in Schleswig-Holstein. There was a budget commission put into life, and they proposed in 2010, I think it was, amongst other measures, to cut fundings for the schools belonging to the Germans, the Danish minority. And just as a side note, they published their proposals on May 26, and this was only 3 weeks after I took up my job at the State Chancellery. And afterwards, I've found like working in the eye of the storm. But I don't want to be pathetic at this point. From a professional point of view, it was a very good time to learn how this minority regime works on a European level and what are its advantages and what are its limits too. Just explain a little bit about this incident. The starting point of the Budget Commission was a structural deficit in Schleswig-Holstein of about €250 million. And their mission was to develop ways out of this and to reduce the deficit in the years to come. And the quintessence of their proposal was, among other things, to cut around 5,300 jobs in public service and to introduce serious cuts in all kinds of public funding. And that should also affect the schools of the Danish minority. And from one point of view, it was all about allocation of funding and of budget and resources. But from another perspective, it was just as much, or you can say perhaps even more, a question of equality between minority and majority population. And because Germany ratified the 2 major treaties for protecting minorities, Schleswig-Holstein is closely involved in this regime, and because of the federal structure of our country, our state, it was Schleswig-Holstein who has to implement these obligations that Germany has overtaken. And this was manifested in very different ways at that time. Unfortunately, the advisory committee adopted its third opinion on Germany on May the 27th. So one day after the Budget Commission's proposal were launched. And at that time, there was a 5-year reporting cycle. And so there was no reaction in the official structures was to be expected. That was a pity, but within the 4th reporting cycle for the language charter, the committee of experts reacted to the developments in Schleswig-Holstein. And during the on-site visit in September 2010 in Kiel, the experts clearly formulated their expectations for the implementation and what should happen and what the government should alter within this. And since the experts not only talked to us, to the representatives of the government or the administration, but they had discussions with members of parliament, with the minority organizations themselves. Their criticism and the arguments quickly became part of the public discussion in Germany as a whole, in Schleswig-Holstein, and in the bilateral relation to the Kingdom of Denmark. And apart from that, of course, this decision was heavily criticized by the Danish minority, of course, and by the Danish government. And I still remember the very impressive demonstrations, like here in Flensburg at the Hafenspitze, with 12,000 people demonstrating, not only from the minority, but also supported by majority population parts of it. And there was much solidarity between the minorities here in the region. So the German minority in Denmark and the Frisian group were supporting the protest. And the Danish head of government discussed this with the German chancellor at the sidelines of a meeting from the Council of Europe. And I don't think that Ms. Merkel was very amused to be addressed like that. So there were many institutions involved, the Bundestag, the Federal Ministry of the Interior, the Foreign Office, and so on and so on. And the media coverage was not very friendly, and there were baskets of letters arriving in the state chancellery, and they were not all of them were in favor of this decision, of course. So to briefly summarize the further development, in the end, everything was fine because the federal government supported a solution, an interim solution, and after the state election in 2012, the decision was revised. And nobody knows exactly in political science what are the reasons for an election decision, but I think, or I guess, it may have an impact, this situation, on the outcome of the state election in 2012. So at that point, I want to leave this example because this episode, which is certainly critical from the minority point of view, but it illustrates how strong and diverse the influences are on the actions of governments and their administrations. There are influences by international institutions and monitoring bodies, by my multilateral and bilateral treaties and the relationship to the neighbor states, by minority groups and their demands, of course, by media coverage and by the public opinion, which is expressed very clear in some points, and by academic discussions, by studies and recommendations that we hear from the scholars. And in my opinion, that was my aim on this panel. The network that we have, this European minority regime, it has proven as a very stable framework that I think is not too much to say. The specific measures are developed within this framework, but they are developed on national and on regional level. And mostly it's a question of compromise, of balancing conflicting interests, and such as this balance between the budget restructuring and the equality for minorities that I mentioned before. And seen through the eyes of a practitioner, this integrated system of protection and promotion in Europe is associated with many chances, but also with a number of challenges. For example, the system is relatively rigid in its reactions. As I mentioned, the advisory committee had published its opinion, and then it is very hard to have an ad hoc reaction. There is this possibility for ad hoc reactions in theory, but I think it's rarely used in practice. And especially for small minority groups who mainly work on a voluntary basis and have little full-time support and have little professional colleagues to help them, the hurdle to turn to the committees is very high. And in fact, I would doubt that the procedure of contacting the advisory committee or the committee of experts or is very well known within the groups in Europe. I don't think that many of them can use this chance that there is. Bello Petai and Rainer Hoffmann mentioned it. Current social, economic, or technical developments that have an impact on minorities, on their languages or on their culture, they are often incorporated with a considerable delay. That, for example, digitization and the effects that the applications of e-government have on minorities, they are not in the treaties yet, and not in the recommendations that we get as a nation state or as a regional body from the evaluation bodies. Or let's say it's very today concern the COVID-19 pandemic impact that they have. It's not in the treaties, of course, and you should react more, or there should be the possibility to react more flexible on developments like that. And over the decades, we have a very impressive number of comments, studies, statements, recommendations, and so forth. For example, for us, the recommendations of the High Commissioner on National Minorities or legal experts on the Framework Convention, they have provided support for the implementation. But to be honest, only very few administrative staff reads these texts or works with them. It's a question of knowledge, or and this is why platforms for an exchange between practitioners, scholars, and activists, they are so useful. And if I could express a wish for the road ahead, which is mentioned in the motto of this event, then it would be to create the opportunity for more exchange between the actors involved, and to create more knowledge transfer and more understanding for the context in which action or decisions are made, or in which expectations are developed. Finally, I would like to sum up my answer with a few points. I think it has proven itself as a very useful frame of reference for us as practitioners, that we can say the European level says, and the advisory committee has pointed out in its opinion that we should act like this and like that. And then with that opinion, we can go to our superiors and say we have to do so, and hope that they believe us. And as a result of multilateral agreements, this regime defines minimum standards, and the implementation is lying with the states. So this leaves a very wide scope of interpretation. So you can do it very progressively to interpret this obligation, or you can choose a more restrictive approach, and it's up to the state which way they go. And in the past, discussions with the experts on the monitoring bodies during the on-site visits or within other encounters like here, they have repeatedly provided us with information on how concrete policies can be designed to be appropriate and to the charter or to the framework. And sometimes the interpretation of the experts and the expectations of the minority groups, let's say, they are in tension with the resources that the government has, is available to a government. and the goal of achieving tangible benefits for the groups at the ground. So the written obligation is very far-reaching, but the question is what is really tangible, and what the minority groups, what is their benefit, their concrete benefit for the people in the groups. And it often takes a long time to come closer in the positions. And sometimes perhaps it can be too late for a minority school, for example, or for the example you choose about the Hungarian secondary education institution. So it can be too late for them when there is an agreement. And at such moments, I feel that this system may reach its limits. And so the idea to have a more dynamic way of exchange, I think this is a really good idea, that the minorities have a lower threshold to address their problems with the evaluation bodies, and to have this exchange of knowledge. Thank you.
Thank you, Linda. Not also pessimistic at all, and quite positive, with many good examples of change, but also of that multidimensional framework within which she said. And I think that example was really a story and an episode from 2010 was very vivid about what's the real situation on the ground. But what's the situation in the ivory tower, Jennifer? And how have you helped personally and others in our field to advance minorities?
Let me begin by saying what a pleasure it is to be here, and also what a tough job I have following these three very interesting presentations. I'm shifting gears for us a bit. I've been asked to navel gaze, I suppose, a little bit, and talk about how the world of academia fits in to the institutions. I was asked to think a little bit about whether academics have led the institutions and have been reactive to political change. And equally, I've been asked to think about the ways in which the world of research has fed into and had an effect upon the world of practice. So I've organized my talk in that way. And I will go out with a kind of dramatic opening move. I think if you look back on the long history of minority issues, you can see a very strong case in which academia has been reactive. In other words, it has followed the institutions. And it has followed them all the way back to the 1920s, when we had a fascinating flourishing of interesting academic studies on the League of Nations minority guarantees. Those of you who have read some of these distant classics, you might well recall, for instance, Asphart, who was himself a member of the Minority Secretariat in Geneva, wrote a fascinating book on how tribunals operated, did it in his study while the bombs fell during the Second World War. We had some very interesting work, again, immediately after the war. Janowski, Robinson, looking back at the League, thinking about whether it had worked or whether it hadn't, and when it worked well, and what we could learn from it. And then it all came to a grinding halt. And it came to a grinding halt around about the late 1940s, when a decision was taken at international organizations, and I'm thinking here of the United Nations in the first instance, but later on the Council of Europe, not to do another minority rights regime. Instead, the standards talked about human rights, not minority rights. The League was regarded as a failure. And academic research went elsewhere. It really followed, in effect, the money, research grants, literally. Also, of course, following the priorities of the world of political life. And so if you were interested in thinking about what we call minority issues for a long period of the Cold War, you would be reading very good work, but it wouldn't be presented first and foremost as research on minority rights, research on minority issues. It would be research on ethnic conflict, or nationalism, or consociationism, or constitutionalism, or boundaries, or of course human rights, which was flourishing. And therefore, really only a few significant works stand out during this period. Again, very early on, you had no less a scholar than Innes Claude, very big name in the study of international organizations. His first book, which I think was his doctoral dissertation, was looking at national minorities as an international problem. Jean Laplante had a very interesting career, was president of the International Political Science Association for a long time, 1960. He had a fantastic book, again, International Protection of Minorities. Modine, of course, wrote an excellent piece on European law and minorities, but there are exceptions. And again, in the main, the research is framed otherwise. This changes most dramatically around about the year 1990. Not at all to surprise, I think, when we've been talking about European minority rights regime, because this is the moment, of course, when that regime was created. And fantastic scholar, I think one of the early links with ECMI, Osborne Eade, wrote in 1990, minority rights was a growth business. And so it was at the time. We had obviously the standards being developed, we had the instrument of the High Commissioner being created. The 1990s were an exciting moment to be venturing into thinking intellectually about minority issues. And I'm going to date myself and most of my colleagues at this time, because if you look now, who are the scholars on minority rights, we are by and large of an age. We have an age which came of age exactly in that 1990s moment. And this was such an exciting thing to study when we were interested in the new standards, when we were optimistic about the acquis and enlargement, and when there seemed to be a kind of wind of change and lots of opportunities and scope for development. Fast forward, of course, 25 years, we're longer in the tooth, so are the institutions. And I suppose what begins to worry me a little bit, this is going to switch me over into my second point, is that the bright young things of today, the ones that we were 25 years ago, aren't anymore doing dissertations on minorities. They've moved, again, they're following the hot topics of the now. They're interested in populism. They're interested in migration. They're interested in identity politics. They're interested in the digital world in a very big way. But they aren't writing those theses anymore on minority rights and minority protection. And I think that's a possible real problem. Ironically, because of a real success in the way that the Cold War regimes have operated, which was to create what I'm now going to refer to as an epistemic community of experts around those institutions. So the scholars of the 90s and their predecessors, such as Rainier Hoffman, of course, wrote one of the early big books of the 90s, along with Patrick Thornbury, again, bringing back attention to these works. The institutions that were created at that time created a role for experts through the independent advisory monitoring instruments that were linked, for instance, to the Framework Convention and to the Languages Charter. And if you look, of course, at the names, for instance, of the advisory board of ECMI over the long haul, you will see a remarkable coincidence of these names moving from the advisory board into the advisory committee of the Framework Council, involved in the charter, involved in the High Commissioner's office. So that closeness of the epistemic community, I think, is part of what's allowed those instruments to function. It has evidenced the fact that the experts very much do share an understanding of the problem. They share an understanding of the norms that ought to be involved in addressing the problem, and they know each other very well. And I think they know the instruments very well. But again, we are all aging together. And so when I think of the future and when I wonder who will be here 25 years from now, I will be well into my 70s at that point. I'll take my vitamins and hope I'll be here. But if we think about it, I mean, what will ECMI be doing 25 years from now? And to go back to Rainier's point, I think for ECMI to be here and thriving, and I hope it will be, the institutions need to be here and thriving, and they won't do that unless they continue to grow and to evolve and to be those living instruments. And part of the way that they need to do that is to show that they are moving beyond the world of 1990 or 1995. The digital world beckons. We've seen that, as Rainier's pointed out, in terms of the advisory board. We also have, of course, the High Commissioner's thematic guidelines, Talon, taking on board much more thinking around digital language rights and how that would operate and how the media in a digital age should work. And I think that's all very important. COVID, of course, has hit everything and everyone. And I know there is interest in thinking about the ways in which inequality has been experienced, the way border regions have been disproportionately affected, the socioeconomic hit of the pandemic, and what that might mean. There is another big elephant in the room, of course, and it's one which tends not to be regarded favorably, I think, by the signatures of those instruments, and that is, of course, very much the post-migration communities. And I'm reminded of the lack of a definition, and I'm somebody who actually has always been intrigued by the lack of a definition. But your wording was groups who have been on the territory for several generations. And I guess it begs a big question, well, how many? Before we should start to be thinking about these new communities and how they might be brought in to one and to the orbit of the institutions. We have, of course, had the latest commentary by the advisory committee, I think it was the latest one, on the scope of application, which is trying to kind of nudge it a little bit on a case-by-case, article-by-article basis. But I think, again, this is going to be something which will have to be confronted going forward, both to keep the instruments alive, but also to keep the experts around the institutions, make sure that there is an epistemic community that will be interested and dedicating their research and their scholarship and servicing those expert committees in the way that they continue to operate in the years to come. So I'm going to end it there and look forward to picking up more fully in the conversations. Thank you.
Indeed, thank you, Jennifer, for the clarion call for new generations, and proactively asking the question, who is going to be in this room in 25 years, which is very trenchant, I think. And I would like to actually to pick up on your very last word, to move to the conversation. I think we'll take one or two sort of comments, questions, statements, however you want to put them, hopefully brief enough so that we can hear a few voices, and then afterwards we'll do one roundup, pass through the panel. But we do have a microphone available for those who would like to say something or react to our first round of introductory statements. Good. Hallmann from Bund Deutsche Neuschleswig.
Yes, from the German minority in Denmark. Thank you. Just a comment to that, the story that Linda told. When that happened, the Danish government, of course, wanted to put pressure on Schleswig-Holstein. And one of the ways which they did that was to increase the subsidies to our schools for the German minority of around 80% to 100%. And that is the only time that we have gotten any money from the Danish government we haven't asked for. So.
I mentioned in my introduction minority mobilization, very important development and change. So, absolutely, prime example. Yeah. Other. Yes.
So I want to ask the members of the podium, where do you think, or how do you think that human rights work today, and what are the connection between the human rights and the minority rights? That would be very interesting, and maybe you could look a bit forward also.
Very, very true, very true. Minority rights are embedded in human rights. Yet don't always come together. One, yes, Anton Thompson from the Office of the High Commissioner.
Yes, good afternoon. My name is Anton Thompson. I'm from the Office of the High Commissioner. Thank you for the opportunity to listen to this panel presentation. I have a specific question to Professor Holtman, but to the broader listening here. The question comes from our practice, and that's the question: how can the best advice, for example, state policy, in promoting this balanced approach, which school pupils advantage of democracy, protecting the minority. So they grasp the issues of person balanced approach. And the question I would have then, from the practice of advisory committee, have any models, general models emerged, or is it always up to the contextual judgment depending on the bargaining power, minority versus majority, or key state intervention, let's say other issues. So my question would be if there are any general models we can rely on in based on our advice, justice-based approach, security-based approach in this particular.
Okay. Thank you. Yes. Then maybe we'll bring it back here, this side of the room. And actually, let's start in reverse order because I think this concrete question could be addressed first, not least to Professor Hoffmann, but I hear echoes of are there theoretical models of justice, which speak to academic questions. So maybe we'll shift to my right-hand side. But Professor Hoffmann, this last question of language rights and how that squares with the Permanent Convention, and you can turn on the microphone and.
Yes. Thank you very much for that most difficult and tricky question. I don't have an answer. I don't think I think the answer, well, in the way you gave the answer yourself when you mentioned the context. And I think that is true, and that is one of the things that I've learned in the advisory committee, and which is not very surprising that you learned that, is that situations are never the same. You cannot really take something which proves well in one situation and just move it to the other situation, to another situation. In one the cases we've had, as far as I remember, then I mean they would start. Then you have the situation in Slovakia on one hand, and then you have the situation in the former Soviet space. And the former Soviet space situation is obviously different because I mean there is the hybrid warfare by the Russian government, which is obviously something which is must be of concern to governments in the Baltic states and in Ukraine and Georgia and what have you. So there, the election there, I think, is a different one than in Slovakia, which was the first case. Which we started with Estonia, that was the first case, so to speak, which was also one which my father school and the office was heavily involved in the 1990s, and there the general structure was formulated. It's both legitimate, and you have to strike a balance. And if you want to increase now the concrete cases, the amount of teaching in the state language, you have to do it gradually, and you must not do it from now to then. And it is, of course, necessary that everyone who lives in the country speaks as sufficient command of that language. So that is accepted. And now how you proceed, and the bottom line of the Slovak opinion was that you should not try to increase the knowledge of the state language by means of criminal law, basically, not by fines and not by financial sanctions. And that I think still holds true. Those things now with the situation in the other two countries, Ukraine and Latvia. I mean, that situation is, of course, very difficult because both governments, in a way, for political reasons, seem to want to make a difference between the Russian-speaking education system on the one hand and the non-Russian speaking situation. Then they were very inventive, and I mean, you have all those regulations that sort of exempt from, you have a special regime for those languages which have the official character, which have the character of an official language in an EU member state. And the Venice Commission, for whatever reasons, came to the conclusion that that solution was more valid, let's put it this way, in the case of Latvia, because Latvia is already a member state of the EU, and in the case of Ukraine, which intends or wishes to become a member state. Whether that is very convincing, I leave it to you. Repeat, I think that is the context, and I mean, it would be naive, I think, not to take into consideration if you're in Kiev, you're 800 kilometers away from the targets, and I mean, you can't get that. And that, I think, has to be taken into consideration also when you the national monitoring exercise, or then also in the case of you advising what to do. Yeah, that's a long answer to a short question, and I could have left it with the person. I don't have the answer, but I wanted to be polite. Try to make an effort at least.
Thank you. And I will remind everyone that we will have the opportunity to pursue these conversations and discussions at the reception, that it will be starting in a half an hour. So I do not want to keep people waiting, not least Minister President Stein Günther. But I think we'll start in reverse order. So I'm going to throw the ball back to you, Jennifer, if you want to address not only the models of justice, but also the overlap between human rights and minority rights. And then we'll pop back forth to Linda, and then finally to Laura. Jennifer, please.
Well, I think the big question about what kind of models are we talking about? I mean, we might be talking about justice models, but equally we might be talking more about social cohesion models, and it will depend, obviously, who's doing the talking and what is the context. So if you're thinking about justice models, certainly, there's the idea of justice as fairness. You could think of roles, the idea of beyond the veil of ignorance. We imagine ourselves in the worst possible position we could find ourselves in, and we reason from there. If you wanted to instead look more at a Will Kimlicka type position, where you would be thinking about the obligations of the state, but you would make a distinction in terms of the nature of the groups within it. And in doing that, you would privilege those who were on the territory of the state and were co-opted by it from those who made a volitional choice to move to the territory of the state. Obviously, that gets pushed back as well, because you can say, and this is the post-migration argument back again to us, does the decision of an ancient ancestor bind the descendants forever? And at what point in time do you need to reconsider? The social cohesion model, of course, would look at it very differently and would say, well, actually, we need to be thinking about trust and mutuality, and that has to be there in order to ensure that the social contract in society functions. And then we would have a give and take potentially between different groups within society, and obviously between citizens and the government. So there's a lot of complexity in how you might come at it. To go back to language rights, one of my favorite examples of language rights, I still use it always as a teaching example, it's an oldie but a goodie. It's the good old Upper Silesia schools case. Anybody remember that one? Again, this is back in the league. And it encapsulates a lot of the questions you still see, because it was exactly the point. Who has a right to decide if a child should be educated in German or in Polish? Is it the parent who says my child is German, or is it the Polish newly created, recreated state that says, no, your child is actually Polish? And what happens to the Silesian, who being a Silesian is effectively a little bit German and a little bit Polish? And again, trying to come to grips with that is what makes the subject fascinating for academics such as myself, but obviously extremely difficult in terms of practitioners to be able to tease out. So I do think it would be almost impossible to come up with an appropriate solution absent a specific context, because you need to be responding to it and making sure that the response is appropriate to the circumstances that you find within that particular case.
Another vote for context matters. Linda, what would you like to leave us with?
I think language rights are quite important in Germany and in Denmark too. In Germany, it's always the question about the relationship between Deutsch as Amtssprache, and so it's this state language, and it's the language before before the law, and so it's always difficult to balance these interests of, for example, the source to use their language in court. And for us, it's to use the Frisian language when you give documents to the court. And so to implement it, really implement it, that it happens on the ground, that a Frisian person can hand in a document in Frisian when there's a case before the court. And an example in Denmark actually is about this law about the preaching. The approach is to have all the preachers in Danish, and the question is how to control it, how to implement it, and the question of the position of Deutsch, of the German language in Denmark, because it is recognized by the language charter and by the Bonn Copenhagen, and so on and so on. And so this, again, it's a question of the balance between the state language and the minority languages. And I think it's very important to find a solution for the position of minority languages. Yeah.
Thank you. And Oran Leche, you'd like to conclude us?
Well, many interesting, provocative ideas also from the questions. First on human rights, I tend to agree with Professor Fernand de Balen, who is now the UN Special Rapporteur on minority issues, and he clearly says that minority rights are human rights. So it cannot be taken away from this format, and I think it's worth also looking more closely to the UN system and what can be done at that level. There are some positive evolutions. Let me say this shortly. Now on the OSCE and the different hot topics, Ukraine and so on, I would say that we would need a principle in international relations regarding minorities. And one principle should be no acquired right can be taken away, can be lost. And that would end a lot of discussions, and especially the one on the state language and on education in Ukraine. I think that the problems Ukraine is facing does not start and does not end with the knowledge level of the state language of minorities. Ukraine is confronted with the fact that a large part of the population speaks Russian language. There's an anecdote that in Ukraine, even the government meetings are held in Russian language. So I do not see that it's the Romanian minority or the Hungarian minority's language knowledge, Ukrainian language knowledge matters at all in that sense. I even would go further, and I would debate with the statement that the state would need a sufficient command of the language, ask for a sufficient command of the language from the minority people. Why? I mean, what is the state gaining from the minority that knows the state language or not? My grandmother had a whole full life, a happy life, but she didn't speak any Romanian. She didn't have the necessity. She was not obliged to do that because she could have her life without the language knowledge. Of course, it is an impediment in being part of the society. It's bad for the young people who want to go to university and don't speak the state language, but it's also a sense of responsibility, a civic responsibility that you acquire the state language throughout your education. But if you choose to learn in a minority school, the state should offer you that opportunity, especially when you go back with tradition, history, that you had this education system. And in Ukraine, it is the situation that the Polish, Romanian, Hungarians had a full language system for centuries, and now they are denied to have a minority education. They can only have in primary education. and otherwise they will lose their language on a long term. And one last statement, because you mentioned the prolific period of the 90s. Well, we need to look back how we arrived to the prolific moment. It was after a war. It was the Yugoslav war that was the triggering moment of the necessity to have minority rights in place at European level, and it is how the Council of Europe managed to have the legal instruments. And that's the very nature of politics. And we as politicians, I recognize it, that the politicians or decision-making processes most of the time work on pressure and with the intention to solve a conflict that threatens its own existence. Rarely we see, especially in my part of the board, positive processes that end up in positive legislation. Most of the time, institutions act based on conflict and on pressure. So I would not like to see minority conflicts that would enable a new prolific international context and new laws. It would rather work on dialogue between minority and majority, and the involvement, the positive involvement of international organizations. So we would like to see this panel discussion also on other levels, because I'm sure those who are in this room, we have the same meaning of this topic. We don't need to convince ourselves, but rather there are others who need this kind of open mind towards this topic. Thank you very much.
Thank you very much. It remains for me to simply again thank the panelists for all of you who have actually traveled here at some distance and some effort. And also, of course, thank the audience, both here in the room and online. And also thank our technical staff and the ECMI staff who's put this event here together. And we have implicitly, of course, already made a booking for this room in 25 years. So I hope that the director of the Danish Library has noted that. But nevertheless, we can chuckle, but it's also a mandate. It's also an assignment for us to move forward in the future. And I think that that's not a small challenge for us to fulfill. And vision to fulfill on many fronts, not only amongst us as people, as individuals, but also within our institutions, within our communities, within our workplaces. So, you know, there is a lot more work to be done, even against the backdrop of so much that has already been achieved. So thank you so much. We will conclude here. But for those of you here, we will walk just down the street and take a small left into the Compagnie Gang, and enter the company tour and enjoy our reception with a little bit of special entertainment promised as well. So see you there. Thank you.